Hello. If you are watching this video, there is a good chance that your child has been assessed to have one or more disabilities, and as a result, you are doing your best to learn more about their educational rights and the history of special education. Since you have found this video with which to educate yourself, I would say that you are on the right track. Special education before the 1970s. Before the 1950s, there was no such thing as compulsory attendance for the students in public education, but starting with the state of Massachusetts in 1852, each state individually passed laws mandating attendance to schools for all children aged 6 through 18, which was completed across the country by 1918. This means that fully 134 years passed between Massachusetts enacting its law and the rest of the states following suit. Unfortunately, this would not be something that would be enacted equally for all students, as it was intended to be. In 1893, just 41 years after enacting their compulsory attendance law, the state Supreme Court upheld that a student with special needs could be expelled due to being weak in the mind and a nuisance to other children. Watson versus City of Cambridge, 1893. In 1919, a Wisconsin court upheld that a student could be expelled because of the student's and educators did not like looking at him, and he used up too much of the educator's time, which they felt should be used to educate the rest of the students. Following this, in 1934, the Cuyahoga County Court in Ohio ruled that certain students with disabilities could be excluded from the compulsory attendance law, despite it being a direct contradiction of compulsory attendance. Department of Public Welfare v. Has, 1934. It seemed like students with special needs would never catch a break, and even as recently as 1969, when North Carolina criminalized persistence in gaining attendance for one's children after they were excluded from public schools due to their disabilities. All was not lost, however. As a result of the political climate, there was a White House Conference on Children in 1910, and shortly thereafter there was a shift wherein students with special needs went from being institutionalized to having segregated classrooms, apart from other students. Following this, a few states, starting with New Jersey in 1911, passed laws mandating that public schools educate children with disabilities. Unfortunately, this did not do much to change the situation for many students with disabilities, because many students with special needs were not being identified, and after either struggling in the regular classroom for too long or having been deemed unteachable, they either dropped out from school or were summarily excluded, regardless of their desire or motivation to learn. After this, in 1933, parents came together to form an advocacy group in Cuyahoga County, Ohio, to advocate for their children and managed to gain a special classroom for their children, although they had to sponsor it themselves. More and more of these types of parental advocacy groups formed. Parents, much like yourselves, of students with special needs, came together to advocate for their children across the nation during the 1930s and 1940s before finally banding together on a national level in the 1950s. As a result of these groups advocating and providing support and information, along with the civil rights movement that occurred during the 1950s and 60s, minorities and eventually people with disabilities were able to gain greater constitutional protections. One such monumental case occurred in Brown v. Board of Education, 1954, which upheld that segregation based on a person's unalterable characteristics such as their race, age, or disability was unconstitutional, which not only ended racial segregation in schools, but also began to have benefits for those who suffer from disabilities. Now let's take a moment and have a closer look at the Brown v. Board of Education case. In the Constitution of the United States of America, it states that all men are created equal. Unfortunately, due to such institutions as slavery, this could not really have been said to be true until after 1965, when the 13th Amendment ended slavery within the United States once and for all. Much later, a set of 5 court cases, which came communally to be known as Brown v. Board of Education, occurred, which called to question whether it was constitutional to segregate schools based on race, and when they came before the Supreme Court in 1952, they were consolidated under the one name. As the justices of the court reviewed the case, it became apparent that they were extremely divided over the issue, and as a result, The case was not concluded until May of 1954, when the courts finally declared that segregation has no place in schools, because what is separate is not equal by its very nature. Now, special education from the 1970s to the present. In 1971, a class action lawsuit was leveled against the Commonwealth of Pennsylvania, stating that the state was failing to provide the students with learning disabilities with a public education due to delaying or outright ignoring their rights to an education granted by the 14th Amendment. The result of this was that students with learning disabilities were found to have a right to a public education from the age of 6 to the age of 21. Only a year later, in Mills versus Board of Education, there was another victory for the rights of the disabled students, when it was found that if segregation based on race is unconstitutional, then so too must be segregation by disability. Following this, in 1973, Section 504 of the Rehabilitation Act made it federally illegal for any agency or activity that received federal funding to discriminate against those who possessed a handicap. Then, more recently, in 1990, the Individuals with Disabilities Education Act was passed to ensure that all children with disabilities received a free and suitable education, and demanded that demonstrable improvements were made in the education of the students. Next, in 2002, the No Child Left Behind Act made schools include the students with disabilities on their score data to determine whether they were being accountable for the students' education. Now, even more recently, in 2021, the United States Department of Education has released a resource detailing how students may become disabled or experience worsened disabilities due to complications from COVID-19 exposure, as well as explaining how they may be able to qualify for assistance under Section 504 of the Rehabilitation Act of 1973, as well as under the Individuals with Disabilities Act. From the early days of educating children with disabilities by simply locking them up in institutions, to the new methods of inclusion and rights for students with disabilities, it has been a long and hard journey to get where we are today. Now that you know a little more about the history of special education within the United States, take a moment and look through these resources in order to further educate yourself on you and your children's rights.